Enoch once more, and we are here again with Lenny with my sensei, and I have not left you yet. We are still going to continue with commercial transactions. We are still on sale of goods, and this is the fifth module. This is the fifth module, correct? Yes. And in this fifth module, we are going to treat merchantable quality and sale by sample, the implied condition as to merchantable quality and sale by sample. Please join us, and it's going to be quite fun. Okay, the implied condition as to merchantable quality is governed by section 14 sub 2 of the Sale of Goods Act of 1893, and it states that where goods are bought by description from the seller who deals in such goods, whether he is the manufacturer or not, there is an implied condition that the goods shall be of merchantable quality. So, in that general provision, there are two things that are very, very striking there. That one, the goods have to be goods that are bought by description. And in our previous modules, we have explained the different types of goods, and this is why it's actually important to go through the videos from the first module till now, because they are all related. And the second thing is that the seller must deal in such products. Whether he is the manufacturer or not, there is an implied condition that the goods shall be of merchantable quality as long as he deals in such goods. But there is an exception, the way legal terms usually work. An exception to the exception. There is an exception here, and the exception is that provided that if the buyer examined the goods, there is no implied condition as regards defects such that such an examination should have reviewed. Meaning that if the buyer examined the goods before he bought them, if the examination that he carried out was meant to review some defects and those defects were not reviewed, the seller won't be under the compulsion of this implied condition as to merchantable quality, because the examination done by the buyer should have reviewed such defects, therefore will not be liable for those things. Okay, and we have a case. The case is British and Overseas Credit Limited versus Anima Shaun. British and Overseas Credit Limited versus Anima Shaun, where it was stated that, in that case, what was the bone of contention was that the seller did not deal in goods of that particular type. So therefore it was held that the implied condition as to merchantable quality did not apply. Remember, one of the conditions that was given in the express provision itself is that the seller must deal in such goods, and in that case it was held that the seller was not dealing expressly in such goods, and therefore the condition could not apply to him. Okay, although the act itself, the Sale of Goods Act of 1893, does not define what merchantable quality means, it is generally deemed to be that the goods will be considered to be of merchantable quality when they are able to do what other goods of that nature do, and in such a condition and quality that a reasonable man after examination would accept them in performance of the contract. The goods will be considered to be of merchantable quality when they are able to do what other goods of such a nature are able to do, and when in the performance of the obligations of the contract, a buyer would naturally accept such goods as performing the whole obligations that come under the contract. What a reasonable man would accept such goods, that's when they will be considered to be of merchantable quality. So many factors determine merchantable quality. It's not just one size fits all. There are many things. There are many factors that influence it. The nature of the goods, the types of the goods, or the parties themselves. But the crux of the matter is that, is it up to the reasonable expectation of the buyer? Are the goods up to the reasonable expectation of the buyer? So it depends largely also on whether the goods are first-hand goods or second-hand goods. You know that this is Nigeria, and many a times we don't buy a lot of things brand new. But yet, the Act makes a provision for this, and this condition as to merchantable quality covers second-hand goods as well. It was held in the case of Shine and General Guarantee Corporations Limited, where the plaintiff bought a second-hand car at a reasonable price. Then he discovered that the car had been submerged in water, and then water had gone everywhere, the engine and everything. And so, he brought an action, and it was held that the car was not of merchantable quality, because the plaintiff thought he was buying a second-hand car for a reasonable price, but instead what he got was a hunk of metal that nobody would willingly buy if they were aware of all the necessary facts, because you wouldn't want to buy a car, even if it is a second-hand car, that would not work at all. So in that case, it was held that those goods, it was held that the car was not of merchantable quality, even though the car was a second-hand car. So therefore, this principle still applies in such instances. Okay? But there is also a slight exception to that. It's not more an exception, more like a qualification. That if the second-hand goods are sold cheaply to represent that there is a defect in them, or to reflect the condition of the property, then you can't really expect a very high standard of quality. I'm going to give you an example of that. In the case of Bartlett versus Sydney Marcos Limited, Bartlett versus Sydney Motors Limited, I believe. So he bought a car, the plaintiff there bought a car from the dealers, and then it was warned by the dealers that the clutch was defective. And in consideration of this, they reduced the cost price of the car. But the cost of fixing the clutch and everything was higher than he anticipated, and he wanted to repudiate the contract. But when the shah took it to court, it was held that no, that he was made aware of the defect, that the car was still of merchantable quality, as he was aware of the defect, and he had agreed to a lower price to account for this. So that's why I said that it's not really an exception per se, it's more of a qualification. So exceptions, general exceptions to merchantable quality. In this course, in this module, you are going to be hearing the word exceptions a lot. But don't get lost, it's piece by piece. Okay, general exceptions to merchantable quality. One, where the defect is specifically drawn to the buyer's attention before the contract is made. Like we said in this previous case, where the defect is specifically drawn to the buyer's attention before the contract is made. If you're already aware of it, you can come and claim that, oh, you were not aware of it. And two, where the buyer examined the goods before the contract. Yes, I mentioned that also earlier, where the buyer examines the good before the contract, and such examination was meant to review said defects. Okay, although we have to also note that there is no obligation on the buyer to examine the goods. So the fact that the buyer has a mere opportunity to examine the goods before the contract does not defeat the entire condition. Just because, that he had the opportunity to examine the goods and yet he still did not examine the goods does not mean that he cannot rely on section 14 sub 2. Examination has to have occurred, and then maybe he didn't see the defects for them to say that, it's an exception and he cannot rely on this condition. But if it's just that he had the mere opportunity and he did not take the opportunity to examine the goods, you can't really say because of that he's stopped from relying on this implied condition. Okay, but there's also an exception to that. Like I said, you're going to be hearing the word exception a lot. The exception to the exception is that if, however, the buyer is given the opportunity to examine the goods and he causes the seller to believe that he has done so, he may be stopped from denying that he has done a full examination. Let me say that again. If, however, the buyer is given the opportunity to examine the goods and he causes the seller to believe that he has done so, he may be stopped from denying that he has done a full examination. You know what estoppel is? When you are prevented from denying something per se. I believe that we have given an expression of that in an earlier module. Okay, so he will be bound by the defects which a full examination would have revealed if he has represented in one way or the other to the seller that, Baba, I have already examined these goods, even though he has not examined them yet. He cannot come and change mouths later that, when I told you that I've already examined them, I actually did not examine them, and then so and so. In such a scenario, he cannot claim such a thing. And that situation came up in the case of the British and Overseas Credit Limited versus Anima Shaun. The British and Overseas Credit Limited versus Anima Shaun. That case had to do with the sale of tin tomatoes. There are a lot of facts there, but what was held by the court simply was that that the implied condition as to merchantable quality did not apply. As the defendant saw the goods, he was put on inquiry that, something may be wrong with the goods, but yet he still accepted them and he was taken to have examined them, because in a way he represented that, I've already examined them, therefore there's nothing wrong with them. So when a problem came up later on, he could not deny that. So now we are moving to sale by sample. sale by sample. Sale by sample is simple, it's straightforward, it's very easy to understand. And it is governed by Section 15 of the Sale of Goods Act of 1893. And it says that where a contract is one of a sale by sample, 16 says that a contract is won by sample. A contract of sale is a sale by sample where there's a term in the contract, express or implied to that effect, that a contract cannot just be termed a sale by sample just because maybe in the negotiations or whatever a sample was brought out. That does not make it a sale by sample. What makes it a sale by sample, according to Section 15, is whether there's an express or implied term in the contract between the parties that this is a contract, this is a sale by sample. And it was held in the case of Gardiner and Gray, that the mere showing of a sample during negotiations does not necessarily make the sale a sale by sample. And Section 15 sub 2 of SOGA goes on to give the details of a sale by sample. That the bulk, there's an implied condition that the bulk shall correspond with the sample, implied condition that the buyer shall have a reasonable opportunity to compare the bulk with the sample, and that a condition that the goods will be free from any defects making them unmerchantable, which would not be apparent on reasonable examination of the sample. Meaning that the goods may have some defects, that even though you have examined them on the face of it, but yeah, those defects are not such defects that can be easily seen per se. So there's an implied condition that such goods will be free from such defects, even though the buyer has conducted an examination, a preliminary examination that does not reveal them. There's an implied condition that the goods will be free from such defects. But there's an exception, like as we usually go. The exception is that the seller is protected from latent defects rendering the goods unmerchantable, which aren't apparent on reasonable examination of the sample by the buyer. Now, it's very easy to get confused here, but there's a slight distinction. That the seller is protected from latent defects rendering the goods unmerchantable. Latent defects can be considered to be defects that maybe go to the root of the property, that are deeply embedded in it to the point that you will not be able to discover it until maybe a large amount of time passes, or you have to take the thing itself entirely apart. That's what we consider to be latent defects. They're a bit much more worse than the earlier type of defect that we said that there's an implied condition that the goods will be free from such defects even though the buyer has carried out an examination. Those ones are basically like, you can't really see them, but they are not latent per se. So that's the distinction. And we also need to touch on Section 55 of the Sale of Goods Act, which says that an express agreement by the parties can exclude any of the implied conditions stated in Sections 12 to 15. From the earlier modules, we've been treating the implied conditions that are in the Sale of Goods Act, which protect both parties. But here we have it in Section 55 that, as a principal rule of normal everyday contracts, the parties can do whatever they want. It's between them. It's a joining of minds. Therefore, this upholds it. That if they decide, they can expressly or impliedly say that, they don't want any of the implied conditions stated in the Act to apply to them. That's why a well-phrased exemption clause can exclude any of these implied conditions and warranties that we have given from Section 12 to Section 15. So thank you very much for watching this video. We ask that you please like, you comment, you share, you subscribe. We would love to have you. And we know that we are trying to do our best and would like you to join us. Thank you from all of us here at Sensei.